Okay, the first one says, only Miss X, the district's autism specialist, has the authority to approve the amount of ABA instruction, an in-home program. I'm not sure if we can offer that.
Okay, one thing you have to remember to tell you about this whole thing is that if there's nobody who can make a decision at your IEP, why are you there? Okay? Your IEP supposedly is a process of decision making. Your district is not only out of compliance, but you're pretty much wasting your time. You might want to offer to reconvene the IEP when the district has somebody who can make a decision. It also tells you for sure that they absolutely predetermined everything that was going to happen there. So again, why are you there if there's nobody there is able to make a decision?
If the district administrative designee is taking long breaks to go talk to somebody at the district office, it probably means that he or she doesn't have the authority to make a decision. The district is legally obligated to ensure that somebody there has the authority and has an understanding of what resources the district has available, but regardless has the authority. If the IEP team determines that an ABA program in-home is what this child needs, then the district official can approve it. And so it shouldn't have to go to the school board. You shouldn't have to wait for the director of special ed or an assistant superintendent to get back to you. The district needs to have somebody there with authority. Next response, we have now exceeded the time for this IEP, so let's wrap this up. You can review the remaining proposed goals and objectives or assessments on your own time after we conclude. Obviously, there are lots of people, lots of parents hear this when you go to IEPs. The district can set a reasonable time limit for the IEP, but if it's not allowing you as the parent to meaningfully participate in the process, that's a denial of your rights and procedural safeguards. The district has an obligation to ensure that you're an active participant in this process. If they set a 2-hour time limit, and that's not enough time to address all your questions and concerns, guess what? You're going to have to schedule another IEP.
But make sure they're the ones who are in it. I know this is kind of hard because you all have really demanding schedules with your kids. Make sure you've got a babysitter to go as long as it's going to take so that you're not the one who says, gotta go. My sitter said she had to leave at 5:30 and it's now. So please set it up so you're the one who has an open-ended. So if it's not going to conclude, you're not done. And bring your calendar with you. If you have a sense that it's going to take longer, you can just say, okay, well, then I guess we got to reconvene. Let's open up our calendars. I'm available next Tuesday at 11. Who else can meet at that time?
What if you've never allowed me to participate? Either they filibuster you the whole time. We've had maybe 10 IT meetings, and they have never allowed us to take the assessments and go over them. We've had letters we have to go over this.
You're saying they don't allow you to participate if you don't send a letter, or they, regardless, they don't?
Most of the IT meetings, they talk the whole thing.
Sure.
They talk the whole time. And I've asked numerous letters. We've assessed them to experts. We like to go over them, and they just don't put it on the agenda, and they don't do it.
That if the district is wrapped up in discussing items of concern that they have and they're members of the IEP team, then you need to ask for a specific IEP to discuss your concerns. Dedicate the entire day if it takes that much time. I've had IEPs, and sometimes districts get really frustrated with this. I've had district attorneys on the other side, I'm not saying like the DA, but the district's lawyer come back and say, we really don't want to spend so much time that everybody's getting frustrated and everything else. And I tell my response is, you know what? If we need to schedule it for tomorrow, I'm available from 2 to 5, or I'm available from 9 to 3. And sometimes they'll just say, I think one response that we had at an IEP that Lynn and I had attended together was that he kind of threw up his hands and said, okay, fine, we'll just take the whole week. We'll just do an IEP for a whole week. I said, so be it. If that's what it's going to take to ensure that the parent has an opportunity to meaningfully participate in this process, to include all their concerns and have all their questions answered, then if it takes a week, then we'll do it. I've had, and this might sound funny, I've been to IEPs that are catered. It takes so long, it's 3 days long, and they have drinks and food and everything else in the back because that's just what the parents have requested, and in this case, the district was willing to comply. So, a 2-hour IEP, it's usually not going to be enough. Certainly, if the district schedules a 45-minute meeting, just say, look, we may as well just find another day if you don't have enough time to go over these things, because 45 minutes is just a drop in the bucket. It's never going to be enough time to get through anything of meaning. If it's an annual, certainly not enough time. An annual, the yearly IEP where you're going over goals from last year. If it's a triennial, it's a 3-year IEP, definitely not enough time because we're going over assessments possibly that the school district has done. and it's been 3 years since the assessment, so make sure you've got an adequate amount of time. I would schedule 8 hours for an IEP at the very least, because it's going to take lots of work to get through each one of these things. And there's a step-by-step process. You're going through last year's goals, you're going through present levels, you're going through new goals, you're discussing and developing. And this is supposed to be a collaborative process. Everybody is supposed to be involved, and again, with the parent as the most important participant in this process. Okay. Okay, so the next response, we did not provide you with a copy of our assessments or proposed goals because, well, isn't that why we are here to discuss the reports and goals? You as a parent need to know what to expect to a certain extent at this IEP. You shouldn't be presented hot off the press with a copy of assessment reports for the child's triennial evaluation. You need to make sure the district understands this, and it's very clear in writing in advance that you expect them to provide you the assessments prior to the IEP so you can digest this information, so you can be prepared to participate in this process. They would expect that from you if you had expert reports. In fact, they would probably demand it. So it's your right as a parent to make that request and to tell the district that if I don't get these reports, then we're just going to have to postpone this IEP.
Let them know what that time frame is,
Right.
and then let them know, okay, today is Tuesday. I had told you if I didn't have them 48 hours that I would have to reschedule. I regret that we have to reschedule, but I don't have it. If you can have it to me now by Friday, these are the dates I could meet next week, okay? Which is the same thing. Cracked me up. The other day, a parent sent me an email saying, what do I do? My district says they have to have independent assessments 3 weeks before IEPs. No district does that for parents. I said, you write them back and you tell them you're so excited to know that because you didn't realize from talking to all the parents you knew in the district had a policy of giving out assessment reports 3 weeks in advance, okay? Remember, put the ball in their court. If they're saying they have to, parents have to, then they have to. So thank them and let them know you want all your reports and that you can share it with all the other parents in the district that they can expect to get their reports 3 weeks in advance.
School districts spend a lot of time trying to get around getting the assessment to the parents, mostly because it's just not convenient for their staff. They're usually rushing into the IEP. They got the report in hand. They made changes to it the night before. And it doesn't allow for a very efficient process, and it doesn't allow the parent to be very involved in this process if they have no idea and they're seeing this for the first time. So even though the school district, you need to, when you word your request, you need to let them know that you expect them in advance, that you expect them a certain number of days in advance. The district, by law, has to provide you those reports upon completion. Where you run into problems is if they're actually completed the day of the IEP, then you need to let them know that you will not go forward with this IEP. You do not give your consent unless you see these reports in advance. Okay? Next one. It is our policy to come to a conclusion at the end of the IEP regarding the offer of placement and services. Therefore, we need to know today whether you agree to our offer. It is the district policy that parents have 48 hours to accept our offer. I can't tell you how many times I hear that question or concern from people who, in many cases, have been my clients for a long time. The district, they spend a lot of time trying to rush through this process and telling parents, giving these arbitrary deadlines that mostly have to do with convenience. Maybe they need to get a contract off to an independent agency. I mean, if they explain it to the parent, they say, look, we can get it in place by Monday if you get the signature back by Friday. That's one thing, but to tell you you got 48 hours to get back to us, or, in some cases, they tell you the offer expires, or, we can't, you're never going to get services. I mean, these are the things that parents hear from school districts all the time. And, we've heard a lot of, there's a lot of concern. And so keep in mind that there's no deadline. It's not 48 hours. It's not 24 hours. It's not 10 school days. You have as much time as it's going to take you to make a decision, to understand what's on this IEP. And as I mentioned before in earlier session, take the time to go through it and understand it and thoroughly review all the goals, all the present levels, make sure it's accurate. And if you feel that something needs to be added, prepare a letter, prepare an email, and ask that it be attached as your parent comment section if you haven't already included everything you wanted to say.
Now, as far as this district policy, before you go to your IEP, practically every school has a website now. And you can actually go through and read every frickin' policy your district really has. And I encourage you to do that. I mean, not read every word, but familiarize yourself with those policies. So if you're an IEP and somebody says it's their policy, you can look them back in the eye and seriously say, you know, I read through everything on your website and I didn't come across this. Can you tell me where it says that? Okay, because there is no district policy. What they're saying is convenient for the IEP team. And so when people say things like that to you, you really need to come back with them in response. Last year at Autism One, Mark Blacksell, I don't know if anybody said, he did a presentation called On Bullshit, okay? And in his case, it was about, you know, how kids have been injured. But the whole paradigm of on bullshit, how people will lie directly to you, I think applies really well to the IEP process.
Okay, you do not need to take notes because we are taking notes that will be reflected in our discussion today. Who's taking the notes? The school district staff are taking the notes. So depending on their level of ability as a note taker or what their position is in terms of the offer, the notes are often going to be very skewed or often incomplete. Okay?
This is another reason why you have to audio tape your IEP. However, whatever it's going to take. There's a lot of great digital recorders out there that you can pick up. You could even use your camcorder, even though they won't allow you to actually videotape. Whatever it takes, because you need to be able to listen to it afterwards, and you need to document things so that you can correct it with a parent addendum. Like it, Spencer's, I realized later on his notes, it said that the behaviors had recommended fading the aid. Well, she didn't. It was great. I listened back to the recording that Tim had made that was digital. I transcribed that part, and I wrote a letter to the superintendent saying, here it is. Here's transcribed. I would like the meeting notes amended to reflect what the behavior said, which was she saw him in summer school. She couldn't comment until school started. That hardly says, I'd like to fade the aid. Okay? So, go ahead.
And at times, and this is something that you're, if you have a lawyer or you're thinking about getting a lawyer, your lawyer may want to do to prepare for an upcoming due process hearing is I have a court reporter come to an IEP and just take a transcript of the IEP because that's really helpful for me as an attorney in going through, and we submit it as evidence. And certainly, it's also important that they will take notes and to review those notes at the end. Take your own notes, record the IEP, and review their notes, and tell them, no, I think this is missing, or I think that's not really what I said, or that's not really what the speech therapist said. She actually said this. And make sure that, you know, to the extent that they'll agree to make changes, and sometimes you'll have school districts that refuse, saying, these are our notes, take them or leave them, then you document that as well. You either ask for a separate notes page to write your own comments, or you write a letter and ask that be included as part of that IEP. Okay? We can't offer that program or service because we simply lack the resources to do so. Or, it's not a matter of what the child needs, it's a matter of what the district can provide. Every school district has a duty to provide a program and placement services that are uniquely tailored to the child's needs. So whether or not they have something in their district, could be a real small district and they've got 2 schools, they've got 1 special day class for every type of diagnosis. If that's not going to meet your child's needs, then guess what? We're looking at a program outside the school district, maybe in the county, that's run by the county, or perhaps a private school. We could be looking at a private parochial school. Gosh, perish the thought that the district would ever have to pay for a religious school, but it's their obligation to do so, okay? Don't buy into the separation of church and state issue if it comes up, because if the child requires a program at a parochial school to benefit from his education, the district cannot offer one, they have a duty to fund a program that's appropriate. And I've had, many of my clients have given notice and placed their child in a private parochial school with the proper supports, proven that it's appropriate, or negotiated agreements with the school district where they've agreed to reimburse for the cost of those programs. So that's going to be a common problem with school districts, is they just want to offer you what's available in their school district without regard to the child's needs.
This is why I want parents to start in the beginning, because a lot of parents tell me almost as many excuses as their school district does. Well, my school district, they don't have this, and they're really small, and I think not smaller than my school district, I bet. Or all the reasons why it can't happen at their school, and I don't encourage you to do that at all. If we're going to work on a program for your child, let's start with no barriers. Let's talk about your fantasy program. Let's consider what your child really needs, and then let's work backwards to achieve it and expect the same thing from your school. Because if that program doesn't exist, you can do what I did. You can find somebody who lives maybe in another, I mean, I live in a really big state, so I was able to find, I live in Central California, somebody who lived way in Southern California, which in some of your states could be 2 states away if you're on the East Coast, who flew in, and we did an out-of-area workshop, okay? You can create programs where you live, get it going, have your psych say, yes, this is progress, this kid needs to have this, and then have your school district pretty much force it that they have to do it. So you can, don't start with what your district will do, because you're pretty much going to doom your child to a special day class.
We import service providers, appropriate service providers, all the time. If you're in a rural school district, the school district can pay for somebody from an area where they have the resource to fly up there, like Lynn was saying, or to establish a program or to do a workshop. There's a lot of things you can do that aren't included in the placements that the district has to offer. So don't get, we need to encourage the school districts to think outside the box and to tell them that you understand that, do some investigation on your own. Find out about private schools or find out about programs if the district doesn't have something to meet your child's needs, and let them know, I understand you can buy that license for $900, and so in the county next to us can provide it, and I'd be happy to transport my child and have you reimburse me for transportation. Okay? Just offer them options, because they're not going to come up with these options for you. It's going to take a certain amount of legwork on your part as a parent to go and look for an appropriate program, even if it's outside the school district, and tell them that you understand that they could have to pay for this.
And I think you'll have a much higher level of success if you present the whole package to them. Like I did. He can be at the Montessori school. He's already there. You can pay the aid there. You can reimburse me, whatever. It's human nature. Hand them something they can just sign on and reimburse you for. If you can afford to float the money each month while you wait for reimbursement, okay, you're much more likely to be successful to do that. And in Spencer's case, his behavior still lives 200 miles away, and our school district just keeps paying for her to come every 2 weeks to check on his program. They can do that, although they won't say that they'll pay for private schools and they'll pay for behaviorists to come out of the area, because I just don't live in the kind of town that could support a full-time behaviorist yet.
That's a perfect example of a case where we had to do a lot of research to find a behaviorist, a company that was willing. In this case, this company is going to set up an office locally. But they weren't around. They were in Southern California, and we had to import them. And it's possible. You just have to help the school district do their job.
Get on the
because
phone
they're not
and call
going to do
the
it themselves.
agencies. That's what I did. I called agencies until I got a couple agencies to come to my area.
Okay. Your child's needs would be best met in a special day class with other students who have similar disabilities, rather than with an aide in the general education classroom, regardless of what those needs are. We hear this all the time. School districts, you need to understand, they have existing programs, existing special day class programs or autism-specific programs, and oftentimes they want to warehouse every kid with the label into that program, regardless of that child's needs. And that could be for a variety of reasons. Sometimes if we're talking about a child who's higher functioning, that kid who's going to be placed or would be placed in this autism-specific program could serve as the model. Their intention is to have him be the model for other kids in the program. Not that it's a bad thing to have models, but it may not necessarily be appropriate for him. Okay? We're looking at the least restrictive environment. So remember, we're looking at a regular ed placement with supplementary supports and services. If that can't be achieved and the child can still make progress or can't make progress with that model, then we can look at a more restrictive placement. Okay?
And the thing you have to remember, too, is this is going to come up because we're talking about, often general education, talking about least restricted environment. Don't buy into the argument that we can't give your child the aid because he'll just become dependent, okay? Because that's a self-fulfilling prophecy, because when you put in, it's true, it's just true to a certain extent. Yes, if you bring in somebody who's totally untrained, has a heartbeat and a background check, and they don't understand what they're supposed to be doing. I mean, most of the time, those extra days, they think all they're supposed to do is keep a lid on Spencer or Johnny or Beatrice so they don't disrupt the other children. And that's not why they're there. A good ABA aide in the classroom is there to foster independence, to facilitate it, to move in when there's a problem, and then fade it, okay? So that it's clear to the child and everyone else that the teacher is the top dog. It's the aide to keep the child focused on what all the other children are doing, okay? So don't buy into that argument that anyone says that the child will become dependent if they have an aide. Yes, if they have a bad aide, but if they have a good aide, there'll be a lot of data keeping, and if the child is not making progress in that setting, then we need to look at the data to say, why is it that he still needs the same level of support 3 months or 6 months or 9 months down the road?
Number 8, there's no need to do an independent educational evaluation because we just assessed your child, and you don't want your child going through the stress of another assessment. Well, as a parent, we talked about you having the right to ask the district for funding for an independent educational evaluation, and their responses can or must be one of two. Either they pay for it by a qualified person of the parent's choosing, or they can initiate due process to prove their assessment that you disagreed with was appropriate. Okay, and remember, they have to provide you with a list, but there's nothing in the law that says that you have to choose anybody off that list. Okay, so it's important that the parent feel comfortable with this independent person. This not be somebody that is closely connected with the school district, does a lot of work with the school district. It should be somebody relatively independent, and we should be able to move forward. Don't buy into it's going to be too stressful. If you don't agree, then get an outside opinion, because it can only help you to better understand your child's needs.
And when you do that, contract with that person directly, okay? If I know every now and then I have parents who don't have the resources to float the money, meanwhile, but if you can all avoid it, what you want to do is find the independent evaluator yourself, sign the contract with them, because that means you're going to get the draft first. Okay, so you can correct any problems that are on there, because I don't think I have ever read a report where something wasn't, and it can be really significant or it could be really small, that's something wrong. You need to correct it, work with your evaluator. If you do it the other way and you let your district contract with that person, they can set a lot of terms. They can say, we don't write recommendations in this, we don't want this, we don't want that, and all of a sudden, that independent that you fought for just became really essentially worthless. Yes?
And that's their obligation,
Yes,
either
that's
pay or
theirs.
file. You could, and that happens on occasion. They're probably going to want to try to strong-arm you into signing some sort of settlement agreement, waiving all claims under the sun. Don't do that. I mean, I don't think it's worth it for the independent. I think that if you send a letter saying, okay, we draw my request, I'm not going to have the district pay for this, it's likely their case would become moot, which means they wouldn't have much of an issue because you've already resolved what was at issue, which was essentially, we want funding for this. The district said they didn't want to pay.
So the issue is that they're taking the due process that they're paying for, not that you want to
Whether they have whether the issue they have to prove is that the assessment they conducted was appropriate. I mean, they might want a stipulation that their assessment was appropriate. You might get away with agreeing that you're not going to come after them for the cost of the assessment. But in all practicality, it's really not worth it for them to litigate a due process over an independent assessment that, which just say runs $3,000 or $4,000, even $6,000 to $10,000, because due process is very expensive, and most school districts do have counsel, and they are going to spend a lot more than that defending or prosecuting that case in due process. They might spend $15,000. Okay, I've had districts that filed for hearing on an independent behavior assessment that parents requested, and ended up losing the case. And we've had, they ended up paying $17,000 or thereabouts in attorney's fees for an assessment that essentially would have cost them $1,500. So it's just not cost effective. And I think if you've got a district that's somewhat business-minded, and that's not always going to be the case, but if they can just do the cost-benefit analysis, it might be a bluff on their part. They may not choose.
That's what I was just going to say. Remember, they're playing poker too.
Yeah.
Okay, if they file for due process, a lot of times they're bluffing. They want to see what you're going to do in response to that, and that often depends on how good their assessments are. I mean, you have to evaluate their assessment, because a lot of times the best thing to do is you can show an independent person, okay, like a psych, like Perlman, to look at and tell you, do you think this is defensible in court? If they think it meets minimum standards, then it wouldn't be worth it for you to go after it either.
I guess my biggest concern is the district council being paid by the hour. And you
That-
can pursue items that he may lose anyway.
And that happens sometimes, and that's why we ended up going to hearing on a $1,500 assessment and having the school district end up losing and having to pay all this in attorney's fees. Not going to happen every time. Still, you have to be able to rebut the arguments they're making. They have the burden to show their assessment's appropriate, but if you can't show that it's not in some way, it's going to be harder to win your case. So in most cases, I advise if we're going to go to hearing on that issue, I would have my clients just move forward with the independent assessment because you're going to have an expert to testify. So you may as well pay out of pocket for that independent assessment, or try to litigate as many of the issues in one due process hearing rather than just going for that. Maybe you can, if you're planning on filing for due process and you plan on getting this independent assessment anyway, then file a separate due process complaint and include those issues and try to consolidate the two cases. So you're just doing it once rather than going to hearing on one or two issues each and every time. There's a lot of different, of course, every case is going to be completely different, and you need to judge it on the case-by-case basis, but you need to look at the cost-benefit and find out what works out best for your child and your situation, your financial situation, your mental state. It's a very stressful process. It's litigation. So you're going to have a lawyer, and it's lots of money for experts and everything else.
How does the school's budgeting process, in other words, how much money they're allocating to things affect timing and how?
Everything.
It does affect it. Go ahead.
The word often that's used is encroachment, because how
Yeah.
it works is your school gets a certain amount of money for special education, and they can only spend it on special education. But especially kids with autism often costs them far more. And so all the money that you spend, so let's just say they get $13,000 a year or something for your kid, or $17,000 for a child in special education. But if your child has an ABA program, or you go to due process or anything else, maybe your child could cost them $40,000 a year, or maybe just $19,000. Whatever that other amount is, it has to come out of the general fund. And all attorneys' fees have to come out of the general fund. So the reason
they can't use special education designated funding, Part B funds, which Part B of the IDEA funds to pay for attorneys' fees and things along those lines. They have to use general funds.
So that's really often where a lot of the hostility comes from at schools, because they get really mad at parents saying, well, yeah, but this takes things away from other children at the school, because the problem is that most of your kids' schools, even without the special ed kids, there never was enough resources. Unless you're an unusually affluent district, there's not enough to go around for anybody. So we're all fighting over the same pot of money. Whether
they pay or litigate could also depend on what part of the year you're in, because they've got a short-term budget. We're not thinking long-term here. We're thinking of 5 years down the road, and how is providing an intense program going to remediate this child, making him a more productive member of society. They're thinking about 3 months or 4 months of budget, and that's all they have to look at. So they make decisions based on that.
That's really important to remember, I think, when you're negotiating with all these different people at your state agency or your school district. You're the only one who has a long-term interest in your child. Everybody else has a short-term interest. They're almost kind of like talking to people in customer service when you call in for support. Mostly everybody just wants you to get off the phone.
Outsourced ones. So,
go ahead.
Which are more difficult sometimes.
You were asking for what? Can you speak up? Services? Group services versus individual services? Boy, that's a crazy one. On all of that, what you'd have to say is, can you show that to me? Can you cite your source for that? Because that's not accurate. But I have had parents say about therapists saying that the group is more effective and that you can do this or that. And I just love to see the studies that show whatever it is that you can put it in a letter too to follow up as you're a parent addendum, or just ask for prior written notice as to what is it. And that's a nice thing to do that I do a lot, is I ask for clarification. And I do that for two reasons, because one, puts a legal obligation on them, and number two, it often gives people room to save face. Because one thing I like to do in letters, and I advise parents to do, is to ask for clarification. Because then sometime an upper level administrator can respond to you and say, oh, it looks like there's been a miscommunication, Mrs. Arnold. I know that it might have seemed like they said that to you, but they didn't understand, and this is what it is. And sometimes you can get something better than you originally would have gotten by letting someone have room to back down.
Or in many cases, if you have an attorney and that your attorney writes a letter to the district's attorney, they will talk to their staff and find out what was said, and they'll use the same language. Apparently there was a miscommunication, and they're doing an about face on their position.
And you know there wasn't, but
Yeah.
I let it go.
No,
Right.
that was, yeah, it's usually that was actually what was said, but it's now recharacterized by a lawyer for the district.
The challenges with the group minutes is who is indexing what level they are. And a lot
Let's-
of times in our school district, when we question that, we are told for privacy issues, they cannot reveal that.
Okay,
If you have a Down syndrome child who's not.
no, but the
Are we legally allowed to require, not to know the names, but to know what that group.
how it works is the confidentiality, and schools really play that confidentiality thing all the way around. That's why you need to read FERPA. It's FERPA, so you understand, and you can read about, go to Wright's Law and put in their search engine FERPA, okay? So what they're talking, when confidentiality is personally identifiable information, and that's not what you're asking for. You're right. You don't need to know that his name is Johnny Matthias and his blah, blah, blah. That's not what you're asking. And in fact, you don't even care. All you're saying is, my child, generically speaking, can only be with children that, well, like in my case, Spencer, he doesn't have speech therapy with anybody else who has autism. Everybody else has got, like this one kid's got this slight lisp, this other kid's got this whatever, and that's who he should be in speech therapy with. He's the one with the social deficit. It wouldn't do him any good to be with other kids with autism. So you can describe, so if they don't want to tell you who's there, then you say, well, then I'll go ahead and describe, and you can, that's who he needs to be with.
Okay, we're going to
Okay,
pick up
go.
the pace a little bit. So number 9, if we determine eligibility under autism or autistic-like characteristics, your child will be labeled for life. And you don't want that, do you? So school districts I like to get around providing services, and oftentimes, if you have the label on the spectrum where autism or autistic-like, it's an easier case, or at least it's less difficult to argue for services that may be required for your child. So it really depends, but sometimes school districts just, as a routine, do not offer, let's just say, one-to-one ABA, one-to-one behavioral intervention services to a child unless they have that label, okay? So don't necessarily be afraid of that label. Your child's file is confidential. It's not going to be published, okay? And certainly, everybody here, I think, has accepted the fact that their child is you know, if you have a child who's on the spectrum at this point. So I think it's important that you not be fearful, because districts will play on that. And
You know what else is really funny about it too, is most people will find when their kid's in school that their teacher never even looked at the IEP or never even looks at their file. So it's pretty funny for them to talk about. You wouldn't want them to be in his personal record forever. Like, yeah, like anybody reads it. Has everybody on the IEP team really read, you know, Spencer's 70-page IEP document? I don't think so. Okay, so, and I would guess that that's true for most people, that most of the kids, you ask, especially if the kid's in general education, I'll bet you money that teacher has not read the whole thing.
How big is IEP really 70 pages?
Yeah.
Sure.
I think Spencer's last set had 39 goals.
Yeah, lots of goals.
We've had a lot of experts work on massage, Spencer, work on it from all different angles. Yeah, a lot of schools try to limit the goals because it'll be so overwhelming for
So-
him to have too many
Remember what we
goals.
talked about with goals? If you have a fewer number of goals, you're addressing fewer deficit areas, and your likelihood of arguing, convincing the school district to increase the level or the intensity of the service is diminished as a result. So
You know,
it's
go ahead. You have to goal that. We do that by going down each goal at a time. We address one, and the answer cannot be, we've already got too many. It has to be, is this appropriate or is it not appropriate? That's the real question, not are we at the limit. I think one time they tried to shut us down at 25 and said, no,
yeah,
there is
there's no limit of goals. You can have
Kept
100
going.
goals, 150 goals. Certainly, you want to stop at some point. You need to be able to have some good, some reasonable, objectively measurable goals. And I think that there's sort of a reasonableness cutoff Because if the IEP is 200 pages, it's going to be hard for all the service providers to actually get this done in a year's period of time. So let's go on to number
We
10.
have one more question right here. Go
Okay.
ahead.
To prepare for the IEP, it sounds like you should have a bunch of assessments already done in order to be accepted.
You know what? That is a good question for the next breakout because it depends on where you are. Okay? It depends on if we're going to be the passive-aggressive parent or we're going to be the assertive parent, and it depends. So it depends on if we're starting the new IEP or we're trying to revise an LP. So let's come back to that, okay?
And when Lynn is talking about the breakout session, we're talking about the last session that we have today, and
8A
that's
and
8A and 8B. Revamping an existing IEP, and hit the deck running, the first IEP. Okay, so the option is not in our drop-down menu. Therefore, it is not available. This is a real comment that we get from districts all the time, especially when we're converting from the handwritten IEP to the computer-generated IEP.
Like how Spencer that
special
said no
educators-
services on minimum days, and they had
Right.
to leave it that. They're going to have to leave it that way because that's the new form. It
So
says
if it's
no
not
minimum day
there,
services.
then they can do it the old-fashioned way. They can cross it out and write it in by hand.
Yeah, that's what they
There's nothing in the law that says you can't do that, and there's nothing in the law that says it's got to be on a computer. But you know, you get locked if you're a school district official in this little box.
They
and
paid
you
a lot
don't-
of money for that program, and they want to
Right.
use it.
Made a hefty investment in the program. So just don't buy into that. You know, obviously it's on a piece of paper. You're going to have to print it out. You can add things by hand. You know, if it's going to make it more inconvenient for the school district, unfortunately that's the way it's going to need to be until they correct their program to include that item in their drop-down menu. And that's possible. You can talk to the techies like Lynn.
Yeah.
Okay, number 11, it is not our policy to make your choice, or it is our policy or is not our policy to assess a child without first conducting a student study team meeting, or our policy is to provide students with IEPs up to 2 hours of speech therapy per week. There's a variety of our policy type comments, and I would say the majority of the time there's no such policy. It might be something that was handed down from somebody's supervisor, but if you go on the website, like Lynn had commented on earlier, you'll get a clear picture of what the policies actually are. There may be some that are loosely based in policy, but many aren't, and they might be speaking out of ignorance. That's just more convenient for them.
And remember, they're district-wide policies. You cannot have separate policies for the parents of special needs kids. Because I tell you what, I bet if you go to your kid's school, there are all kinds of parents who bring in video cameras and all sorts of things that they won't, for birthday parties, little plays, whatever, okay? But all of a sudden, if you want to do something in a special day class, they're all, oh, confidentiality, okay? Because they don't want anything documented in that crappy special day class because it's just babysitting, okay? Well, whatever that policy is, then they should better have a no camera, no video camera, okay? Because if the kids in regular ed can have cupcakes on their birthday and mom brings in so she can do all her scrapbooking, well, I'm sorry, but special needs moms are scrapbookers too, and they should be able to bring in all that same stuff. So don't go for any of these policies that are just for special education. And that's something that you might have to work up the chain of command to your superintendent as to why can't parents of children in special day classes volunteer. And again, go back to the website because your school district's website probably has this really pretty little paragraph in the mission statement about how they want parents to be involved. And that counts for you too.
Okay, number 12, we believe a 2-week or summer break between services is important because sometimes kids just need time off. Well, there's a different standard, legal standard for a break period, summer breaks or extensive off-track periods than there is for the regular school year. Usually that standard, depending on the circuit, for the most part, circuits have interpreted that standard as preventing severe regression or maintaining acquired skills. However, that's not the reasons why school districts tell you this. They usually tell you this because they don't have anything available for the summer. Okay? Most districts won't have a regular ed classroom available for the summer. So guess what? If your child needs a structured program and it needs to be in a regular ed environment, they're getting out their checkbook to pay for the local Montessori school or whatever your child needs. It's based on his individual needs. If he's going to severely regress, or we're looking at, where you won't be able to maintain those acquired skills, then we might be looking at the district funding a private program, whatever that may be, depending on the needs of the child. Despite the fact that our district assessment has not been finished or provided to you, we consider this assessment complete and are using it as a basis for our offer. You need to see in advance, we talked about this, what they're telling you as part of this assessment. So that's why it's imperative that you make this request in writing, you tell them what your expectations are, you give them a time frame, and if they say they can't meet it, just say, I guess we'll need to postpone that IEP. You know, the district has a duty to hold it within they have a duty to hold the IEP by the child's annual deadline. So at some point, they're going to want to have this IEP. We can't postpone it indefinitely, otherwise they will be out of compliance. So just make sure that they're aware of your expectations, and you're absolutely entitled to get a copy before that IEP. This is an actual statement that was made to one of my associated, well, I guess one of my clients at an IEP that one of my associate attorneys attended. But you know, essentially, they did not allow the parent to meaningfully participate in this IEP by saying, "We're done hearing from you at this point." So essentially, they're cutting the parent off. We don't want to talk to you anymore. We've already heard what you have to say. We're not interested. Obviously, that's more of a blatant disregard for you as the parent and your rights to be involved in this process. I would document that. I certainly hope, and I think we, as a routine, as a policy, tape record or electronically record all of the IEPs we attend for our clients. But that's something that could come back, definitely would come back to bite the district. Number 15, if you choose not to accept our IEP offer and you put your child in a private school, then the school district is no longer responsible to provide your school or child a free, appropriate public education. Well, that's not necessarily true, okay? If you give the district notice that you feel that their program is not tailored to his unique needs, it's not a FAPE for Johnny, and you tell them either at the IEP that you don't feel it's a FAPE and you're going to place your child in an appropriate program and seek reimbursement, or you tell them 10 business days or 10 school days before you place that child, then you are preserving your right to collect reimbursement from the school district for the cost of that program. I would also let them know that you will expect them and you will seek reimbursement for transportation costs. So just because you've chosen to put your child in a private school does not make them a privately placed child. And school districts will routinely say, sure, you can place them, but on your dime. Okay? So you need to understand, parents need to understand that they have a right to place, but they do need to give notice. It should be either at the IEP or 10 days before that placement happens. Otherwise, you could be barred or that reimbursement could be reduced or denied by a hearing officer. Next one, last one. Why don't you just try this program? You can always call another IEP. Be very careful when you agree to try a program. Make sure that there's very specific language in your IEP that gives you the right to revert back to the prior program. Don't let the district convince you to cut its services in half just because you can have another IEP to discuss putting them back into place. If you give them up, it's going to be relatively impossible to get them back. There's a reason why they've recommended that service be discontinued, and they will fight you tooth and nail to keep that program. And what you've essentially done is you've reduced that service or that stay put the child will be entitled to have by allowing his program, his ABA program, for example, to be cut from 20 to 10 hours per week. Okay, so if you're going to try something that's less, make sure that you've talked to an attorney or an advocate who's competent to be able to advise you about what kind of language we put in this. If you truly feel that your child doesn't necessarily need that 20 hours and you're willing to try it, then just be careful, because you're locking yourself into that new potential stay put if you end up having to go to due process on that issue later. Okay. Any questions, comments? Okay, I think we need to move on to our case studies. Thank you for all of you doing your homework on the case studies. Jennifer, my colleague, is going to spend some time going over those with you, helping you spot issues. And then we're going to move on to the breakout sessions.
Thanks for bearing with us. It's very late in the afternoon, so thank you for bearing with us. The one that I want to get to first is actually the third one, because those issues are not written out for you. Now, right off the bat, was anybody able to spot any issues that were concerning to them? okay? One of the things, and obviously all the names in here have been changed, but all of the things that are in these case studies are things that have actually happened with our clients and things that we've seen on our cases. But even though this is a relatively small fact pattern, there's a lot of things that are going on. Social skills is one thing. Initially, right off the bat, with respect to California law, and check with your local special education law attorney, but after a parent requests an IEP in California, and your state will have something with respect to this, an IEP must be convened within 30 days. So my initial concern is a parent has requested an IEP, the district is trying to put it off, and the IEP should be convened within those 30 days. So that's my first thought is this IEP is not being convened timely. The next thought is you can always, if there's an annual IEP coming up, you can always move up your annual IEP if you want to have it sooner because there are concerns with respect to your child. And if that's the case, I would encourage you to move up your annual IEP as opposed to waiting to hold an IEP when you have concerns to fit the timeline for your annual IEP, if that makes sense. And otherwise, in other words, have it sooner rather than later. The other thing is parents should receive notice of IEP dates in writing. If you don't receive notice of IEP dates in writing, it will impede your ability to meaningfully participate because then it becomes an issue of what someone says and what you understood. And remember, part of what we were discussing today is strategies with respect to dealing with the district. Make sure that everything is in writing, including their notification to you about the dates that they're proposing for the IEP. The next thing that's largely concerning and happens to parents all the time that districts try to do is they basically say, here are the dates we're giving you. You choose these dates. If you're not available, too bad, we're going to go forward without you. So right off the bat, if the district gives you that type of an ultimatum, your next thing is a letter in writing saying, I'm unavailable on these dates. I absolutely do not give you consent or permission to convene this IEP without me because it will interfere with my ability to meaningfully participate in developing my child's education. That's the first thing, number one. But the second thing is don't fall for that, because that's absolutely not true, and that's absolutely not the law. The other thing that's concerning with respect to the district's ultimatum is if they're saying that an IEP must be convened on a certain date and parents are not there, or parents don't even have notice of it because it's not in writing, parents won't have an opportunity to actually assemble all their independent assessors. When you go to your IEP meetings, and if you want to make a recommendation and it's based on anything that any of your independents say, you have to make sure that your independents are actually available to attend that IEP meeting. And if you don't have notice, or if they convene it without you, your independents not only will not have an opportunity to talk about what their recommendations are, but most importantly, they'll not have an opportunity to ask the district why their proposed recommendations are appropriate. So that's something that you want to keep in mind. The other thing that's concerning is there's no discussion regarding any interventions regarding this child's social pragmatic deficits. And that's something that Dr. Perlman will speak of, but this is something that actually happened in one of our cases, and the district's response basically was, hey, this kid needs to toughen up. He needs to stop being treated like a baby. He needs to become a young man. And the problem with this is the person in this fact pattern, like what happened on the case, was not a behaviorist. It was just a general ed teacher who really did not understand the implications of a child who has difficulty with perspective taking and being able to interpret social cues in the way that typical children can. So those are all things to keep in mind when you are dealing with districts. Does anybody have any questions just with respect to this?
On the issue of assessments, and they're submitting it to you, is that a statutory requirement that they submit assessments to you before the IEP, or is that different?
Are you talking about district assessments? It's not.
There's not a specific federal statute, okay? So you need to look at your specific state law. But there is a statute that says they need to provide you assessments upon completion. Okay, so what I said was a concern earlier in a prior session was that if they're completed the day of the IEP, then you're going to have a really tough time participating in that IEP because you just got that assessment in the morning. So that's why I always encourage parents and my clients to put it in writing when you expect to receive that. So we can't point to any specific federal law that says they got to give it to you 2 days or a week. What we can say is they do have to provide it to you on completion, and definitely after parent request. You always have access to your records. And that is a part of your student record. Does that answer your question? Okay.
Yes.
It's coming to my attention, my daughter's 8, and that I've never received an assessment.
Oh,
She has had. I don't know how I missed this, but is the school supposed to notify you if they're doing an assessment?
yes.
They have to get your written consent before they do any assessment that they don't do on the regular population of kids. We're not talking about standardized testing they do for every kid. They got to get your permission. They got to get your consent.
Yes, absolutely.
All
Absolutely.
All those. If they haven't, if you've never signed an assessment plan, there are some major procedural violations that have been taking place over the past 5 years since she was 3 years old.
But the good news is sometimes when they've done everything wrong, that gives you the leverage.
Back to leverage again, because we looked at the case, and you got a 2-year statute of limitations. So if you think that, if you want to use that leverage, use it quickly to try to get something in place that you feel is appropriate. Well, that's not going to bar you from going to filing for a due process complaint. It has nothing to do with the school year. We litigate cases all year round. I've got hearing officers that are willing to do a hearing up to Christmas Eve in some cases. Not to say we would want to participate in that, but in some cases they are. And so that's not going to bar you. Doesn't matter. You wouldn't necessarily be able to have an IEP unless the district agreed in the summertime. But you can still make headway by initiating a due process complaint or filing a compliance.
And strangely enough, the school district's been really great, actually, with my placement and
Sure.
everything
Sure.
else. But I'm realizing as you guys are talking that, and we were both in the same school district, and neither one of us have.
You've never probably had an opportunity to challenge any of those assessments because you've never got a copy of them.
Right.
Yeah.
Upon completion, and certainly if you ever requested the school district has to do, you might want to just make a request for your entire cumulative file, just so you take a look and see what's actually there. Yeah.
One other thing that I did want to mention, guys, with respect to this fact pattern that I didn't mention that's very important to me or whoever is your special education attorney is one of the things that happened is there was an admission made by one of the district people. The general ed teacher in this fact pattern talks about the fact that his bullying is interfering with his ability to learn, and that's one of the things that you want to talk to your behaviorist or your psychologist about, because sometimes districts will take the position that when there are social deficits, that's not their responsibility, and their only responsibility they have is remediating what they perceive as an academic deficit. So that's just to give you a heads up to watch out for that as well. With respect to the first case, does anybody have any questions on that? Yes. It should have been.
That's an issue, Nora. Yeah, that's one of the issues in this case.
Yep,
Yeah.
but remember, they dealt with it because he needed to toughen up. So that was their perceived way of dealing with it. But you're absolutely correct, there were no interventions, nothing that was done.
Academic services, now under the new IDA, isn't that expanded? And how do we have a counter argument towards that? That's what's been repeatedly in my school, we need to just focus on the
answer that
academic needs, not
If-
on the lifelong skill.
That's a very good question, because there are new regulations, both Code of Federal Regulations and, well, at least in our state, California's got, is working on new regulations. But with respect to the standard, we're actually over time. We've got to do some other sessions. Do you mind if we take your question a little bit later? Okay, because I think that's a good discussion topic. Okay. We're going to repeat the questions because they're doing a recording. Great. All right.
Does anyone have any other questions? Yes?
One that relates to assessments.
Mhm.
Does the district have to get consent from a parent to modify the assessment? In other words, they're administering the test to find out where the deficits are. They put modifications in place that I was not aware of.
What do you mean? Do you mean
Testing.
that they're now seeking to determine whether or not there's another suspected area of disability, or that they're trying to do different types of tests?
Like if the test required him to answer a question, but his verbal is low, what they did is they gave him a choice of answering 3.
That's a good question for
Dr.
Dr.
Perlman.
Because it really depends on the test. Some test instruments will say you can't give this test with any modifications. You have to do it exactly the way that the test administrators, whoever the test makers say you need to do it. So some tests, like, I guess some environments could be modified, but correct me if I'm wrong, Dr. Perlman, but you would have to look at the type of test that's being administered?
I actually didn't hear the question.
Okay. The question was, can they modify the test or the assessment during the process, and still, are you concerned about the validity of the assessment results?
Modified it, but I could have given them a better way to modify it, so my
Okay.
kid scored. So if I had known that they were going to modify it, I would have sent him to computer-based if that was allowed, and let him answer on the computer. He would have scored better. We probably would have gotten a better picture of him. But they put modifications in place and never told me. So are they allowed to do that?
Allowed legally, or there's two different questions, really.
Well, they can put modifications, but my concern is if we're modifying a test that says you shouldn't administer this test with those modifications, then you're not going to get an accurate result on that particular test.
Right.
So that's...
So anyways, I don't know if this clarifies. So the question is can the test be modified? And then your other question basically is I'm just repeating it for the tape now, is can your, are they allowed to do that without informing you? Okay, I can't answer the second one at all, but I'll leave that one to Tim. But the first one, really, the tests need to be administered under standardized procedures. Can a test be modified to depart from standardized procedures? Absolutely, but then the score becomes less relevant, if not totally irrelevant. But someone can report that. So especially with TBI kids or with children with autism, but TBI kids, I might modify a test and now they can't say it verbally, and I can put a pointer on his head so he looks at it and the laser pointer chooses the picture, and I just report that. I still score it and I report that, what modified conditions that I did that under. And you're saying the third thing, which is, gee, if you had known, you could tell them how to modify it specifically for your, and that's a great point in that I don't know how you're going to get that in there. As an examiner, if you have that for an independent examiner, then, I always have parents observe while I do the testing. I love it, but I'm like Mike Mulligan in the steam shovel. The more people, the better it is, But as long as the child is okay with that, I love it when parents do. Because I want parents to do just what you're saying, which is, gee, ask me, could I do it this way? And then I'll determine whether it can be modified that way or not, or if he fails on that way, whether I just, yes, we'll do the modification, I'll just report it that way in the test results. But I don't know about what a district's obligated to do.
There's going to be a certain amount of flexibility if the district says, specifically in their assessment plan, which should be a written plan that you get in advance, that you signed your consent to before they start the assessment process, that they're only going to do these tests in this way, and they modify that, then they violated your right to give prior consent to that assessment. You expect them to do the assessment a certain way, and they change it. They do a different type of assessment. They use a different test. Does the law say they have to use specific tests? No. They don't have to, and it's really, the law is not going to delve into what the test says they can or can't do in terms of modify, because tests change all the time. They get updated. They may throw a test out depending on how valid they think it's going to, what kind of valid results or invalid results they're going to get from that particular test. So it's a little bit subjective on the district's part. They could do some modifications, but I think as a professional, as Perlman said, you'd have to report that in your written assessment report. You would have to say, I did this test, but and to what extent it would have affected the validity of the results, and you'd have to explain what modifications you did in the report for it to be a valid assessment, because it has to be administered in conformity with the test maker's instructions. Okay?
Okay, before I take any more questions, I'm just going to touch base really briefly on the prior two fact patterns. With respect to case number 1, the thing that I wanted you to be aware of and be concerned about, the idea of a district proposing what they call a more intense program for your child, which to them necessarily equates to no longer offering other types of services. In this fact pattern, you saw the district believed that the categorical autism special day class was more appropriate, and on that basis, they proposed terminating the in-home ABA program. When a district proposes terminating any of the programs or services that your child is receiving, the first thing as parents that you're going to want to know is, what's the basis? Is this based on data? Is this based on observation, or is this based on your subjective belief that what they perceive as a more intense placement will be able to help other areas of need? That's the first thing. The second thing is you always want to be in touch with your independent assessors and find out what their opinion is regarding termination of any services. In this particular case, as you know from reading the facts, the district proposed terminating several of the child's programs. One of them was the in-home ABA program. And the theory was the placement is so intense that he no longer needs it. Meanwhile, the ABA program provider didn't believe it was appropriate, had data to show that the child's behavior was not such that they could terminate it, and as well, there was absolutely no transition plan, so they were just going to cut this plan cold turkey.
Question the district's motivation for wanting to move your child to a different program, especially a lot of districts that we're seeing in California have invested tens, if not hundreds of thousands of dollars in developing model autism programs, and they're trying to shift placements of kids who are more high-functioning in regular education classrooms with aid support, and also kids with one-to-one in-home ABA programs into these quote-unquote model autism programs. It's just a lot more efficient for them, but not necessarily appropriate for the child. Again, we're looking at his unique needs. What is their motivation for wanting to change this? If they don't have a good motivation other than, hey, it's our new autism program, and we'd like to try them out, that's not a reason to switch, okay?
The other thing with respect to case number 2, the big takeaway points that I wanted you to think about and be concerned is when districts are telling you that your child is making great progress in their programs, ask for the basis. And your independent assessors will be able to help you with this. But for example, on this case, we had a child who had the same test administered I think roughly 11 or 12 months apart, and he had made about 6 months worth of progress. So in a year, he didn't even make a year's progress. The district said, hey, he's making some progress, therefore he's making progress. So be very cognizant of what your definition of progress is and what the district's definition of progress is, because some districts will allow the gap between your child and the other children to continue to grow so long as the child doesn't stand still.
Because it's a subjective determination, that doesn't necessarily mean because he's only made 6 months progress in the 9-month school year or the 12-month, whatever 12-month period, that the district has denied him a free, appropriate public education. Again, you have to look at what Jennifer's discussing more specifically is he continuing to fall behind as his peers continue to progress? Is the gap continuing to get wider? That's going to be a reason for you to be concerned about the future. What's going to happen next year? Okay, his peers are going to continue to be 6 months and then 12 months and then years ahead of him eventually if we're going down this path.
Probably question, the definition of regression.
And I'm sorry, I can't hear your question.
You're talking about regression.
Mm-hmm.
Because for us to get like ESY services or additional
Sure.
services, we have to demonstrate that they are regressing. Is that how you define that, by the gap continuing to grow?
Well, if the gap is growing, you're not necessarily, you may not necessarily be seeing regression, but the child could be making progress, but is it de minimis progress or is it adequate progress? Is the child making enough progress? I mean, because the standards is so subjective, I mean, the district's always going to say, hey, we've met our legal obligation if the child's making some progress. But if it's a really small amount of progress, that gap will continue to grow. What you're talking about with extended school year is if you have data to show that your child's going to regress severely during the off-track period, if he doesn't have a program in place, then the school district would be obligated to provide an extended school year program during that break period, during that off-track period. I think it's helpful to, I mean, you'd have to show that there's some data to support your position that there's likelihood for regression. I think it's easier, cases where the child did regress the prior year. I think those are easier cases to prove, but because you've got some data to support that. But if you have an independent expert that's helping you to gather that data and present it to the school district before the extended school year break happens, then the school district is in a much they're going to have to make a decision whether extended school year services are necessary for that child. It's just, it's going to be, it's really going to come down to how much support do you have for your regression, the regression argument that you're making. Okay, is he going to severely, and severe regression is what most circuits, how most circuits or many circuits interpret it. So, you know, again, we're looking at a rather amorphous standard. I mean, what is severe regression? Well, severe regression for your child. If we're, you know, what the example that I've given in the past to parents and my clients is, if the child is at a certain point in June and they go the entire summer without services, and it takes them till, they start in September again, it takes them till December to get back to the way they were in June, then they've severely regressed. Clearly, that's severe regression. Okay? If it takes them 2 weeks or 3 weeks, I mean, even a neurotypical child's going to regress somewhat during the summer. So, very subjective standard. I think it really is helpful to have that data to be able to show that there's going to be regression. And that's different than what Jennifer was talking about with the gap growing, because the child may not necessarily be regressing. He may maybe just not be making progress as quickly as his peers. And the point is, his peers will continue to make progress, and he'll, depending on how slow that progress is that he's making, he'll continue to fall further and further behind, which we don't want. We don't want to get to a point where he's 3 years behind, you know, because the gap continues to widen. We want to close that gap. So that's where we're going with that.
The other takeaway point, of course, is when they say that they're making good progress, ask for the data that supports that. Often you'll find that it's based on a teacher's subjective opinion, based on her recollection of how your child was at the beginning of the year and how she feels your child is doing now. More often than not, you will find they do not have objective data that shows that your child is making the type of progress that they're claiming your child's making. And if we don't have any more questions, what I'd like to do is just hold off so we can begin that last breakout session. We'll be available after the breakout session for any questions